A very good afternoon and welcome back from lunch. We'll now move into our second session for the Sports Arbitration Conference with our speaker, Chris Anderson, Head of Legal Services of Everton Football Club. But before I invite Chris onto stage, just some brief words of introduction. Chris joined Everton in March of 2014 as Head of Legal Services, and before that he had previously worked as a specialist sports lawyer and a corporate lawyer at a Magic Circle firm. As Head of Legal Services of the Everton Football Club, Chris is responsible for all legal matters at the club. Even prior to joining Everton, Chris worked as an external legal advisor in football, acting for many clubs in the Premier League and Scottish Premier League. Of interest, I also noted from his profile that some of the football transfer matters that he worked on and advised on included the matter involving Tottenham Hotspur on the still the present world record transfer of Gareth Bale over to Real Madrid. So if rumours are to be believed, and if Gareth Bale were to come back to the English Premier League, perhaps Chris will have some experience to also share on that matter. So without much further ado, we'll be starting with Session 2, Football and Arbitration, Onside, by Chris Anderson. Chris.
Thank you for the introduction. I can say in regard to Gareth Bale, it's probably unlikely I'll be involved in his transfer back to England. I don't think he'd get in the Everton team. As the chairman said, I'm Chris Anderson. I'm the head of legal services at Everton Football Club in the Premier League. And in English sport in general, and English football in particular, arbitration is de rigueur. It's very common, and it's how we look to resolve our disputes. So I'm going to talk today specifically about football and English football experience of arbitration and dispute resolution, and share some of my experience of how it works and some of my thoughts and experience. But I suppose, although we're in an arbitration centre, and this might be a slightly odd thing to say, whenever I'm asked about litigation and arbitration, and my number one tip with a bullet by far is don't do it. Don't arbitrate. Don't litigate. Don't have disputes. Basically, I would infinitely prefer not to have any disputes whatsoever. But if there is, that's utopian. And if there is any industry in the world which doesn't have disputes which need resolving, it's definitely not professional football in England. I can promise you that. And it's with that in mind that football has in the past looked as how best to resolve its disputes, and a commitment to not necessarily go down the court route. In the Chairman's Charter of the Premier League, which is a document that at the start of every year the chairman of each club is asked to sign, it provides that we will ensure that our clubs will seek to resolve differences between each other without recourse to law. Now, without recourse to law, well, you could resolve disputes any number of ways without recourse to law. You could end up having duels at dawn, and I dare say that might work quite well for Everton, because our chief executive is really into his physical fitness, and I reckon he'd do quite well. But really, what we're talking about when we say without recourse to law, we're talking about arbitration. And the structure of arbitration, if you're in the English Premier League, it looks like this. We look at, and we have to deal with, two really distinct legal systems, one of which is a common law legal system, and one of which is a civil law legal system, which can sometimes make switching between the two quite tricky, and some of the concepts in the civil law legal system are sometimes difficult for an English lawyer to understand. Happily, I originally qualified in Scotland, so that's a mixed legal system, so I'm okay. But looking at what we face in terms of arbitration as a Premier League club, domestically we've got two sets of arbitration rules. Firstly, those of the Premier League. Broadly speaking, those are applicable wherever we have a dispute with another Premier League club or with the Premier League itself. And then the rules of the FA, and broadly speaking, they apply whenever we have a dispute with anyone else in English football, I guess. But then when it comes to international matters, UEFA and FIFA are applicable, and both UEFA and FIFA are Swiss-regulated entities and Swiss-incorporated companies. So if we have a matter that falls under FIFA's jurisdiction, and that when FIFA deal with it is a Swiss law matter, but then when it moves on from FIFA to the Court of Arbitration for Sport, that again is a Swiss legal entity, and ultimately, as many of you may know, the point of appeal from the Court of Arbitration for Sport is to the Swiss Federal Tribunal. Now, that's only on certain limited grounds, and by far the majority of Court of Arbitration for Sport cases end at the Court of Arbitration for Sport. But that is an outline of the structure that you're dealing with and that you face as an English Premier League club. And what I thought I'd do for my talk is look at, from the English football perspective, two questions about arbitration. How does arbitration and how does that structure come to be in English sport and English football, and why has arbitration become so popular as a dispute resolution mechanism in English football in particular? So to first deal with how, a major attraction of arbitration is that it is the only method of dispute resolution that can oust the jurisdictions of the courts in England. That's a very old principle. The oldest case I'm aware of is Thompson against Jarnock, 1799, which establishes that principle. But the modern law in England is set out in the Arbitration Act 1996, which is, I suppose, our version of Malaysia's Arbitration Act 2005. And I won't go through line by line the Arbitration Act 1996, but one provision that embodies the principle of ousting the jurisdiction of the courts and is important in a sporting context is Section 9 of the Arbitration Act 1996. And that provides that where there is an arbitration agreement and a written arbitration agreement, there is a mandatory stay, a mandatory suspension of any court proceedings in favour of the arbitration provisions. And the key phrase there is a written arbitration agreement. And in sport, a lot of the time, the question is looking for where is the written arbitration agreement, because there isn't often in a sporting context, as there would be in a commercial context, a written contract of what's going on, as you would in the direct sense of party A and party B, and they're doing X, and that's got a provision in which says any dispute between the party goes to arbitration. What you get instead is the courts finding that there are written arbitration agreements via other routes. And by far the most common, I think, and certainly the one that's most common in English football, is that the rules of the competition organiser contain a provision in them that says that any disputes go to arbitration. This is the one for the Premier League, and as you can see from the slide, it says quite simply, by virtue of being a member of the Premier League, that constitutes an agreement in writing between us and each other clubs and the league that will submit all disputes which arise between us to final and binding arbitration in accordance with this section of the rules. So because we are a member of the Premier League, we have to agree to the rules that are in the Premier League handbook, and by virtue of agreeing to the rules in the Premier League handbook, that is our agreement to arbitrate, and more generally as a contract between us and the league and between us and the other clubs. There are other ways in which this written arbitration agreement can be found in English sport. I mentioned one case there, Medal against British Athletic Federation. That case related to a doping matter in which an athlete was subsequently exonerated. But this particular part of the case was about whether or not there was an arbitration agreement. And certainly Diane Modal hadn't signed anything to say that she accepted arbitration. But the court didn't have any problem with saying that the arbitration rules of the British Athletics Federation applied to her, because as an athlete she had entered into competitions under the rules, and by virtue of her conduct she had accepted that the rules applied to her as a contract. and that included the arbitration rules. Now, one of the things that I think as a lawyer is quite interesting when you think about arbitration in a sports context is, the foundation of arbitration is that we have voluntarily, two parties have voluntarily agreed that instead of going to the courts, they will go to, and it might be obvious from our example in terms of the Premier League, but also the Modal example, that kind of voluntary consent, there's a question mark over how much that is there in relation to sports arbitration, because we at Everton Football Club don't have a choice in picking and choosing which rules of the Premier League we accept or not. So we couldn't, for example, say, well, we want to be a member of the Premier League, but we don't want the rules of arbitration to apply. So how free is that choice is a question mark that sometimes comes up in understanding the legal academic foundation of arbitration in sport. And in England, that question was actually tested in the courts by an agent called Paul Stretford. Now, Paul Stretford might be known to some of you because he acts for and has acted for many years as the agent for a player who used to play for Everton called Wayne Rooney. Now Wayne currently plays for a team called Manchester United, who I can confirm did lose to Everton 2 weeks ago by 3-0. Thank you. I'd like to think that applause is because you're all Everton fans, but I suspect there may be another reason. But anyway, but Stretford did take this issue of lack of consent. He was an agent, he wasn't a player, but the FA at the time had rules on the conduct of agents, and to be an agent acting in English football, you had to be licensed by the FA. And he'd been brought up on some disciplinary charges under the FA's disciplinary rules, and he sought to challenge the whole disciplinary system in court. Now, the FA's response was to say, no, court doesn't have jurisdiction because there are rules of arbitration, and therefore Section 9 of the Arbitration Act, which I mentioned earlier, applies to stop any court proceedings. And Stretford's arguments was that he hadn't agreed to the FA arbitration rules. At no point had he said, well, FA, if you and me have a dispute, we'll resolve it by virtue of a Rule K arbitration, as it was. But also he advanced a second argument, which was that even if the court felt that he did have an arbitration agreement with the FA, the arbitration procedure that the FA had didn't comply with Article 6 of the European Convention of Human Rights. Now, Article 6 is the convention in European Union law that guarantees the right to a fair trial with certain procedural safeguards. So Stretford advanced those two arguments. And he wasn't successful. The court said, well, you as an agent, you've engaged in a course of conduct under the FA rules. You've done FA deals. You've got a license as an FA licensed agent. So you've engaged in a course of conduct, and because you were engaging in a course of conduct, you had a duty to read those rules. And the fact that he hadn't read Rule K didn't matter. He had a duty to do that. So they had no problem really in concluding that he had accepted the arbitration rules, and there was an agreement to arbitrate disputes between him and the FA. And they also rejected the fair trial arguments, because they said, well, arbitration as a voluntary agreement that people enter into to resolve their disputes can be an informed consent to vary the procedural rights and protections that you're guaranteed under the European Convention, and that, in the court's conclusion, was what has happened here. So Stretford didn't get anywhere on lack of consent. A couple of other areas that might be interesting in years to come, I'll just mention in passing. Competition law in the European Union, and mirrored at a domestic level in England, provides that a body in a dominant position can't abuse its power in the marketplace. Now, by definition, all of the English and European and world governing bodies are in a dominant position because there's no other game in town. UEFA are the dominant player, and there isn't anyone else who provides those kind of European football competitions. So it's not just a dominant position, it's a monopoly position. Now, I think if a challenge is going to come to arbitration rules imposed by a body like UEFA, it will probably in the future come from a suggestion that by requiring arbitration, UEFA is somehow abusing its dominant position in the marketplace by forcing people to accept arbitration. I'm not sure I agree with that, but I suspect if anyone does challenge it, that'll be what happens. Another case I mention in passing, only because it's not an English case, it's a German case, but only because of what happened in it, involves that lady there, Claudia Pechstein. Now, Claudia Pechstein was a German, and in 2009 she received a doping ban, and there was no question that she had an arbitration agreement in place. I mean, she had signed various forms to enter competitions that accepted jurisdiction and arbitration and the Court of Arbitration for Sport. So there weren't any of the kind of issues that I've mentioned earlier. But she went through all the usual channels of challenging this doping ban and actually went to the Swiss Federal Tribunal, but wasn't successful in any of those. But she didn't end a legal fight there. She actually tried to sue the doping authorities in the Regional Court of Munich in Germany. And the Regional Court of Munich actually took a different view to the English court in Stretford and accepted some of the consent arguments. They said the arbitration agreement was invalid because she had been forced to sign up to it because she had to sign the form to compete, and she had to compete because otherwise she couldn't work as her profession. However, it was something of a Pyrrhic victory because she'd served her ban by then, and she was denied her damages claim, so she didn't really win anything. Now, when this decision came out, there was a concern, I think, in European sport that this would somehow undermine the structures of European sport and the use of arbitration. The case is on appeal, so it may not even stand in Germany, but ultimately, I think we haven't seen any major changes to the European structure. Courts, including the English court, have taken a different view. I don't really see this having much effect, certainly on us as an English football club, and I don't think it's likely to have much wider effect. But one to keep an eye on as it works its way through the German courts. Now, I've mentioned how arbitration arises in a sporting context in England. One other area that I want to mention before I move on is that sometimes you get arbitration agreements without either party particularly realising it at the time they enter into the agreement, which sounds kind of odd. But what I'm really talking about in that situation in a sporting context are the procedures that any sport has to have by its nature relating to the conduct of participants and discipline on the pitch, for example. And sometimes the characteristics of the disciplinary procedures are such that courts in England have said, well, this isn't just an internal disciplinary procedure, actually what you've got here is an arbitration agreement. And usually when that point has come up as a matter of debate, it's because one side wants to bring in provisions of the arbitration agreement relating to conduct or things that have happened, and the other side doesn't. And it's not always consistent whether it's the athlete or the governing body that takes either side. And this has come up a few times in English cases, most recently involving a cricket case which involved spot fixing. And I won't go into the details because I don't think they're relevant for our purposes today, but the interesting aspect from an arbitration and a technical legal point of view was that the judge in that case set out in some detail when a disciplinary system would actually be considered as an arbitration agreement. I put the factors up there, and I think the slides are going to be distributed later, so I won't go through that in detail. But I think the interesting point from our perspective is sometimes in a sporting context in England there is an agreement to arbitrate that isn't labelled as such, and maybe when the parties entered into the agreement, they didn't realise it was an agreement to arbitrate. So that can raise some sort of interesting issues when you're acting as a lawyer. So that's the how. That's the technical side of why of how we've tended to get arbitration in European sport and English football in particular. But I wanted to spend a lot of time now on the why. As I illustrated in my earlier slide, there's not many disputes, certainly disputes with other sports bodies that we as Everton Football Club could get into that wouldn't involve arbitration of some form or another. And in a sporting context, I think these tend to be the main factors that have influenced English sport to adopt arbitration. I'll go through them, and then I've got a number of examples that I think illustrate these points quite well. First one up there, confidentiality. One thing that is very clear if you work at a Premier League club is how obsessed the media is with Premier League football. Certainly, if you are ever appearing in a court context for a Premier League football club, the galleries are always packed, and they're always packed not with members of the public, they're always packed with journalists. So the chances of us being able to have a court hearing which doesn't get widespread detailed media coverage are pretty slim. So for Premier League clubs, the ability to have a confidential proceedings, even if ultimately the judgment is sometimes released, which can happen under the rules we've got, is invaluable and something that's really very attractive as a high-profile sporting organisation. Speed, and I think that as well is vital for why arbitrations become so popular. Courts proceed on their own timescales, and those timescales don't often marry up with, in my experience, the timescales of ongoing sporting competitions. A Premier League season runs from August to May each year, and we really need issues resolved prior to the end of the season, so we know who finishes where, who's the champions. For example, if Chelsea have won the league this season, but if there was some dispute whereby 20 points of Chelsea's were at risk and it was going through the court and it wasn't resolved after appeal for a number of years, we wouldn't know who this season's Premier League champions were for 2-3 years. You can see that even more clearly in some of the issues that come up in relation to the suspension of a player. Can that player play in the next match or not? Well, if something has to wait for a court proceeding, it could be years before you know. And it may subsequently turn out that the player should have been banned but played in games and then had an effect, and that had a sporting impact in games that the player shouldn't have played in. But on the other hand, whilst the player is appealing something to a court, could you suspend the player? Because if it then turned out the suspension was wrong, well, he'll have missed out on playing in games, and you as the team will have missed out on having a player available who should never have been banned in the first place. So I think some of the mess that would occur from courts being the body that resolved ongoing sporting disputes in a competition are a major factor why arbitration is so attractive to resolve sporting disputes. Another major factor, having the chance to have an expert panel. I always say to people that working as a lawyer in sport sports law is certainly in England, it's like normal law, but normal law viewed through one of those crazy funhouse mirrors, and you get them in Malaysia, but circus funhouse mirror which distorts things and makes you look fat or tall or thin or whatever. You'll recognise the legal concepts, but very often the way they work is just odd. So having an expert panel who know not just law but also know the sport and know your sport, I think is invaluable in reaching legally robust resolutions, but also resolutions which make sense from a sporting perspective. Flexibility on procedure, again, is really useful for football clubs. Reduced costs I've put there as a question mark. Generally speaking, in England, arbitrations are less costly, but that isn't always the case. So that's why I've put it under a question mark. And I think finally, for a sport like football, which has a massive global footprint and is played around the world, we could get into disputes with other entities who are based, the other side of the world from England, and rather than the complex system of conflict of laws and all this kind of stuff which comes up, having a body like CAS, which is generally accepted, the Court of Arbitration for Sport, I think is invaluable in getting a resolution of those kind of international disputes. That's all quite dry and theoretical, but I wanted to illustrate what I see as some of the advantages and some of the whys of why English sport and sport in general has adopted arbitration by illustrating it with a few points. Firstly, I think a great example is the ad hoc division of the Court of Arbitration for Sport. Now, as the name suggests, ad hoc, it's not a standing body. It's a body that's set up for specific tournaments to resolve disputes at that tournament. A great example of what I was talking about in terms of resolving things. Resolving things on a timescale which fits an ongoing Olympics. And what happens is you have 12 arbitrators who are all experienced experts. They are there for the duration of the Olympic Games. They have a specific set of procedural rules, and generally speaking, they have to make decisions within 24 hours. And as I understand it, I don't know the details, but I have this information from a respected CAS arbitrator, so I believe him. The record for a decision was the last day of London 2012. An incident, a hearing, a decision, all had to be made that morning because the decision that was made was going to influence an Olympic final that was being held in that afternoon. And that's a great example of the resolving it on the timescale. There's no way a court could have done that. Any court, however efficient, couldn't have resolved it in those terms. And yet there was going to be an Olympic final being held, so it had to be resolved. So I think the ad hoc arbitration panels CAS sets up are a great example of some of the whys, and has been really successful to the extent that it's now used for UEFA European tournaments and FIFA World Cups as well as the Olympic Games. Another example of I think some of the advantages of sports arbitration and why we have adopted it broadly in Europe are the experts that sit on the panels, and the ability of those experts to come up with sensible sports judgments as well as legal and theoretical judgments. There's any number of illustrations you could give, but the ones I've put up there relate to a principle of immunity of decisions made on the field of play. Now, what I mean by that is referees will make mistakes. I think every decision against Everton is a mistake. As a Scotsman, I think a Russian linesman in 1966 was definitely wrong. More controversial. I'll move on from that one. But what you have is referees make mistakes, and the decisions of referees could be subject to court litigation. You don't have a final result after 90 minutes in football. And what happened in this case, it involved a gymnast who I believe he had gone into the final round of the Olympics thinking he was in a certain place. And the final round had been held, and he ended up getting the bronze medal. And subsequently, it was turned out that going into the final round, they'd added up his scores wrong. It was a maths error, and actually, if they added up his total scores correctly, he won the gold medal. And he, entirely understandably, was a bit upset about that and appealed it. But the CAS said, actually, there's nothing we can do because that was a mistake. The judges got it wrong. But the judges were behaving in an honest manner. And as an athlete, as a sports team, you're entitled to an honest decision. You're not necessarily entitled to a correct one. And they said they, as a panel, couldn't, in retrospect, look at a decision and look at a sporting outcome and work out what would have happened if the decision had been correct at the time. So, in football, someone's sent off and they shouldn't have been, no one in hindsight can work out what would have happened if the player had stayed on the pitch. And in a similar way, they said, well, everyone went into the final round of this gymnastics competition thinking they were in a certain place, and they performed in that final round in a certain way, thinking they were in a certain place. So if the scores had been added up correctly going into that final round and everyone knew really where they were, you couldn't guarantee that this chap would have ended up with a gold medal, because maybe the person in silver medal position would have performed better or taken more risks and got a higher score. So although it was harsh, and as the panel said there, it was rough justice, in the interest of sport, you had to have a final decision. So they said sport has to sometimes accept rough justice. You know, referees and the like will make mistakes, and you just have to accept that. Now, I say it's a qualified immunity because honest mistakes are tolerated, but mistakes or wrong decisions which come from other reasons are not and can be overturned. And in that example, I've put up there Asian Handball Federation against International Handball Federation. What you had was an umpire who was biased and was not making honest decisions, and so his decisions were overturned. So, in the interest of sport, I think that's a great sporting compromise. It's a great sporting judgment and principle. You, however harsh it is, you have to accept the referee's decisions at the end of the 90 minutes. But if that referee's corrupt and has taken a bribe and is making decisions that aren't honest, then perhaps that can be overturned. And I think that to me is the right principle and the right balance between the interests of sport and the kind of legal principles involved. To give another example of the kind of principles that have been developed by sports arbitration, fair play, not just on the pitch but off it. Here's a principle CAS established. They say they'll always have jurisdiction to overrule the rules of any sports federation if the decision-making bodies of that sports federation conduct themselves with a lack of good faith or not in accordance with due process. Very sensible, very fair. Sports regulators must abide by their own rules. Not in my time at Everton, but certainly in my time in private practice in England. You'd be surprised the number of times that this comes up as a question. But it says there, you know, principle which should be obvious but has had to be established. Rules are there to provide guidance to administrators, and if the rules are inconvenient for the administrators or obsolete, well, there are constitutional procedures to change them, but you can't simply ignore them as a you know, the FA can't simply ignore its rules just because they don't work for the FA in a particular case. I think that's right and fair. I do have to mention a bit on the Court of Arbitration for Sport in specifically a football context. CAS, as I illustrated in my initial slides, is the final point of appeal from certain decisions of FIFA and UEFA. Not all decisions. For example, if you talk of a sporting sanction, a one-match ban from UEFA can't be appealed to CAS, but a five-match ban could be, and that's probably sensible in terms of certain decisions. The more important decisions can be appealed, but certain decisions can't in terms of the workload of clubs and UEFA. Interestingly, English clubs, we can't appeal decisions of say, the Football Association to CAS, and the reason is that the rules of FIFA allow national governing bodies to provide for arbitration to CAS all their own rules, and the FA has always taken the view that it would rather keep things in-house than go to CAS. And in fact, a number of years ago, West Ham United actually tried to take something to CAS, and the Football Association obtained an injunction preventing them from doing that. So the FA at the moment is very firmly set against CAS arbitration. From a personal perspective, I think that's a shame. I think it would probably be good for English football if the FA had more independent oversight, and I think actually in the end, in final analysis, it would probably be a good thing for the FA itself, because I often think, and it's just a personal, not a club view, I hasten to add, but I often think that a lot of the good work the FA does is in terms of how it deals with clubs and promotes the game and at the grassroots and things like that we all support, often gets undermined by some of the ways the disciplinary process in particular is carried out, and the lack of independence that generally is perceived to be within that. So I personally think that if something like the FA disciplinary process was subject to CAS oversight, it would be a better process, and it would be a process which worked better for everyone involved in English football. But just to illustrate the importance of football to CAS, jurisdiction of CAS for FIFA and football matters was first recognised in 2002, and I think from 2002 on that graph you can just see the massive increase in the number of cases there were at CAS, and I think something like 2/3 of them in the last year were football related. I think football's had a massive impact on the Court of Arbitration for Sport. Just to illustrate, I think again some of the ways that arbitration can work in quite an interesting and sensible manner in a sporting context. There's recently been a case in relation to the question of, is there a right to play? And this came up in football. And by right to play, I mean, does a professional footballer have the right to say, you've employed me to play in the first team, I have to play in the first team. You, Mr. Manager, you can't demote me, I have to play in the first team. Or if it's not that far, does the player have to be provided with facilities to train with the first team, or is it entirely up to a manager who can, for whatever reason he wants, say, right, you Mr. Player, I don't like you anymore, you've got to run around the track on your own, and I'm never going to pick you for the club again. Which it doesn't happen really in England, but certainly, as I understand from Court of Arbitration for Sport cases, is something that's happened a lot in Eastern Europe, and I'll come back to why shortly. But if you are an English club and you are dealing with questions of, is there a right to play? Well, your start point is what does English law say? And unsurprisingly, English law doesn't say anything directly about the rights of sports people to play in a sports team. What it does say is that generally speaking, there's no duty under English law for an employer to provide work, which is relevant. But then subsequent cases have said that duty is not there. Well, there is a duty to provide work where you're dealing with skilled workers, because skilled workers have an interest and a need to practice their skills and keep them up to date. So that's perhaps analogous to football players. There's also been a suggestion related to cases involving actors, that actors have a right to publicity, it was called, because that's needed for their profession. And I think although sports people are in the public eye, they don't need publicity in quite the same way. So I'm not sure that carries over to sport. But certainly I think football players have a decent argument that they are skilled workers, and they've got a right to exercise their skills and practice their skills to be able to work. Now, the case I was talking about was a case called Eric Salkic versus Arsenal. And I hasten to add, it's not Arsenal, the English Arsenal. It's a Ukrainian Arsenal, I believe. Ukrainian Arsenal. There's a phrase given current politics. Definitely off topic. Anyway, this Arsenal employed a player called Eric Salkic, and Eric's contract said he was a professional footballer, and the case turned on, well, what does that mean? Because the coach claimed that this player wasn't fit, and over the winter break, because unlike in English football, there is a month during the season that there's a break in Russia. I think quite sensibly, because of the harshness of the Russian winter. I think it's viewed that it'd be quite difficult to play football in the height of Russian winter. So there's a month or so where mid-season there's no football played by the Russian teams. And during that period, the coach said to this player, "You're not fit. Can you please go off and train with the second team?" And the second team played in a lower division. He wasn't happy about this, and after 8 days he walked out and claimed that the club had breached his contract, and therefore they owed him money and he was entitled to walk out. Now this is I think a really interesting case in the sense that you get a decision that has to be made about two competing principles of sport. On the one hand, sensibly, I think the CAS felt that a manager has to be able, in a football context, a manager or coach has to be able to make decisions about who is in his team and who isn't in his team. And they were concerned that if they allowed this judgment, then it would open the floodgates to allow any player not happy with his manager, he's been dropped to the bench, he's been made to train with the reserves because he's not fit, whatever, claiming that this decision made by the manager for sporting reasons that he felt a certain striker was better for a certain match than another could be subject to challenge, and they were concerned about this. But on the other hand, the panel said, well, okay, that is definitely a principle we want to recognise, but there is also a principle that clubs can't use this to abuse the position of players. And he noted, and this is why I mentioned the Eastern European thing, they noted that in certain clubs in certain parts of Eastern Europe, there had been a practice that basically when a player became inconvenient because he was too expensive or he didn't fit with the plans, then because the player has a contract for a number of years, and if the player in theory wanted, whether he's convenient or not, he's entitled to continue to be paid and played and trained under that contract. So there'd been a practice of effectively banishing these players to make them quit and therefore save the club money. And one CAS arbitrator I spoke to told me of one club who he didn't name, but they were definitely Eastern European, who had appeared before CAS on cases like this for this practice 12 times. And 12 times in a short period of time. So there's no question that a club like that was using and abusing this kind of principle of moving players around and trying to use it to get players to quit when the player had become inconvenient. So two competing sporting principles and competing considerations there. And really, I think where having experts sitting on an arbitration panel rather than a court comes into its own issues like that. They recognise the player has what are called under Swiss law personality rights, but they also recognise that in sporting circumstances a coach can move players between first and other teams. They therefore, recognising those two principles, then looked at several factors. They said, what's in the player's contract? Does it, for example, say this has to be a player who's in the first team and he has to train with the first team all the time? Because if it said that, well, then perhaps there's a breach of contract by the club. They looked at the reasons behind the player being moved. Was there a genuine sporting reason for it? As the coach in this case claimed, he just wasn't fit, or was there another reason? The reason of trying to get rid of the player. What was the effect on payments to the player? Was he still getting his salary in full, or had his salary been stopped? Obviously, if the salary had been stopped, it suggests that it wasn't a genuine sporting decision and they're trying to force the player out. What was the effect on training? Was the player continuing to train in a professional football context such that they could exercise and improve their skills, or were they training on their own? Key factors. Did the player have adequate facilities to train in? Again, if he was being given adequate facilities, perhaps it was more likely that it was a genuine sporting set of considerations. And finally, was this a temporary assignment to a reserve team, or to train in a different way, or was it a permanent assignment? And the CAS, I think, concluded, interestingly, they concluded, when you analyse these factors, there definitely could be a breach by the club of a right to play. And a right to not necessarily be in the first team, but certainly a right to be training at a sufficiently high level and to be playing some football matches such that the player could continue to be a professional football player. But they concluded that in this case, this wasn't it. This wasn't a case where the club was in breach. So they felt ultimately that the club had acted in the right way, and the player in breaching his contract, the player had actually breached his contract by walking out after 8 days. So that, again, I think is another great example of the why we use arbitration in football. I think having experts on a panel to judge and balance competing sporting interests is invaluable, and I think you get a much better resolution and a much more sporting in the sense of it fits sport resolution than maybe you would get at courts. So in my conclusion, and I couldn't resist at least one picture from the 3-0 win over Man United. I did ask my marketing department, was there any chance of a picture of the scoreboard just saying Everton 3, Manchester United 0, but they said no. It's also the 3rd win in a row over Manchester United at Goodison Park. But there they go. So that's the picture they gave me. So the conclusion on arbitration and football onside question mark. Well, yeah, very much so in my view. I think arbitration is a key part of the structure of world football, and I think it is a much better fit for resolving disputes in world football than the court litigation route would be. So that's me done. I'm delighted to take any questions if we have time. If not, and anyone wants to speak to me afterwards or during the networking events, I'd be delighted. Thank you.
I think we have just about 5 minutes to take any questions. Any questions from the floor? We'll have a mic going around if there are any questions. Yes, I think there's a gentleman at the back.
Hello, thanks for an excellent presentation.
Thank you.
I've got a question related to plans that I remember hearing about a number of years ago concerning Everton and Liverpool building a joint stadium. I don't know where those plans have got to, if they sort of fell by the wayside with the financial crisis 5 or 6 years ago. But are you able to give us an update on where things stand with that?
Yes. It's not happening. I can 100% confirm that. No, Liverpool are redeveloping part of Anfield, and we are looking at a site in Walton Hall Park to. It's quite exciting. It's a council-led regeneration project for that area of North Liverpool, which is an area which has a number of social problems. Walton Hall Park is just round the corner from Goodison Park, and the council have proposed a regeneration project, which a new football stadium for Everton would be the key part of, the anchor that unlocks the rest. But it's a very exciting project that would involve new businesses, new houses, new education provision, new sports provision for that area of Liverpool. So there's definitely not going to be a joint stadium, and we are looking to develop our own new stadium at Walton Hall Park in conjunction with the council as part of trying to help and do our bit for regenerating that part of North Liverpool. So no sharing with Liverpool.
Questions from the floor? Chris, then maybe I'll just jump in with one setup within the Premier League and the FA. I know there was a very well publicized decision involving the Fulham Football Club, because I think some of the Premier clubs, not only are they contracting parties with and of course with a contract to arbitrate, I think they are almost treated as akin to being shareholders of an entity. So from what I recall, it was a dispute that arose from the transfer of a football player involving Tottenham.
Peter Crouch.
Yes, Peter Crouch.
I actually acted on that one as one of the solicitors advising Sir Dave Richards. It was Fulham Football Club against Sir Dave Richards in the Premier League.
That's right.
So
yes.
I do know this case.
Yes.
Yeah.
So are there, is it quite well settled now that arbitration should be really the preferred and only route, where there may be a kind of a countervailing statutory right to possibly bring court proceedings as well? Yes.
Yeah, I mean, under English law, there are certain things that can't be arbitrated. And the case involving Fulham and Sir Dave Richards, who was the chairman of the Premier League then, was all about at core it was Peter Crouch, but it ultimately was about the duties of a director under company law in England and the Companies Act 2006.
Yeah.
And the question was whether or not disputes about issues about directors' duties were one of these categories of issues that were not within the ambit of arbitration and couldn't be arbitrated.
Yeah.
Like, another example, employers can't force arbitration on employees relating to the rules on disability discrimination or race discrimination in England. That's one example. And the question was whether or not directors' duties were one of these sets of rules that couldn't be arbitrated. And I think in that case, Fulham at the time were owned by a chap called Mohammed Al-Fayed, who was a reasonably controversial figure, and very careful what I say here. Mr. Al-Fayed enjoyed a certain public profile, and I think there was a perception that they didn't want it to be arbitrated because, in that case, because it was about the actions of the chairman of the Premier League, they would rather have it dealt with in open court where the press could report on it. But ultimately, to go back to one of the points you were saying about the clubs being shareholders, I mean that's actually what we are. I mean the Premier League is owned by 20 clubs, and we each have a share. So we are the shareholders of the Premier League, as well as the people who play in its tournaments, and that's why Fulham had sought to rely on their rights as a shareholder in that case, rather than necessarily rely on their rights as a body playing within the Premier League. But as you might expect, I think the right outcome was reached in that case.
Yes. Thank you, Chris. And if there are no more questions, or if there are any questions you want to pose privately to Chris after this, we'll be having a short break. But just before I invite Chris to leave the stage, I'd like to now invite Datuk Sundra Raju onto stage just to give a token of appreciation to Chris Anderson for this session. Thank you, Datuk. Thank you, Datuk Sundra, and as well as Chris.